You were here sporadically. I always do. What do you do at home, day?
We are just like set it at its lowest. Set the quality as low, like
Why?
Is that your assumption of the quality of today's debate?
No, it is your speech.
I'll find it. I'll find it.
Apa dah start dah? Ada satu balik. Boleh je.
I have no passport. Ini datang tanah aku.
Tanah kau. Tak pergi. Kau tak tahu ke? Sudah dah duit. And yeah, sure. Can I have the full wording?
This house would ban out of court settlements.
Prosecutors
This is also banned out of court settlement between prosecutors and corporators. Okay, prosecutors and corporators.
Man, I prep on prostitutes.
corporations and private people. But how it was like that doesn't make sense. That doesn't make sense. Like, oh, prosecutors. I thought big corporations and normal people.
Oh.
Like civilian thing, I was like, oh, I just saw everyone.
How you feel? I tried to find like around 2 this morning. That was good.
Aku record semua. But I didn't want to apologize.
Bad near bad deed.
Are you gonna be sitting just now?
Fortunately.
No, you can't sit here.
I know. That's why.
Let's do langkah sikit.
You can just say unfortunately. Unfortunately.
I'm sorry, I speeches for this is for you. How genius.
Oh, the fun.
There always be one.
What's the range now of the tournament? 75.
No, 75.
75.
No,
79 to 92.
It's 88.
Oh, I see. No, but seriously, 65.
65.
Don't mind the incessant figure.
Can you just hold your fist up in
Right.
He licked my palm.
I think you checked my TV. Cool. Cool.
You don't have to sing that.
What?
And I'm gonna break out into a song.
So, Rafiq, so both of us are the responsible ones in the team. Huh?
Yes.
Instead of singing.
Someone's got to actually bring up
Yeah,
material.
we need to do stuff.
Dan, because if this goes then
Alright, mate. Happy.
Number 2, I know.
Thanks.
First time.
Oh, I thought we were waiting for you. J.
Oh, no.
Man.
For the rest of this tournament.
It's okay for now.
Yeah, the one time was like an hour now.
Did you pass out or something?
Tu dia.
Sorry, toilet. This one now.
Hi everyone, welcome to round 4. This is room 4. My name is Sarah. Training with me will be Aline from IIU. She'll also be timing, but I suggest you also like self-regulate just in case she slips or something. And I just want to check the teams. Opening government is IIUMC, opening opposition is Mara A, closing government is Mara F, and closing opposition is Myla Bit 3.0. All right, great. Without further ado, I'd like to invite the Prime Minister to speak for the motion that stands in the name, which reads, this House will ban out-of-court settlements between prosecutors and corporations. Here.
Mr. Speaker, we don't think the benefits or the trade-off of the time saved in these out-of-court settlements outweigh the harms and the evasion of justice that happens when these cases are settled out of court, right? So what do we want under opening government? We want these companies to suffer the full harms of the damages that they've done. We don't want any confidentiality in these processes, and we want this to go to court and take the full course of action in whatever amount of time and money it takes, right? So just clarifying that these harms are not just these are not subjective harms. We think these harms can be tangibly measured if it's environmental externalities like oil spills or deforestation or things like health hazards. We think these can be measured and these can be settled through monetary compensation. However, we think that the amount of this monetary compensation or any other punishment given to these corporations should be decided to the due process of the law in courts. Right. So what will I talk about today? Right. Number one, I want to explain exactly how these corporations exploit the system through the existing backdoors and their lobbying. And secondly, how it is only under our side where we set precedents for proper behavior of these corporations and compliance to regulations, right? Sit down. Number one, how do these firms exactly exploit the system? You have to understand that the people who are within these, the people who do negotiate these out-of-court settlements or people who are within these regulatory commissions, these are people who have been selected from within the industry. It means these are people who know how the system works, who have actually interacted with with the CEOs, with the board of directors, and they have the incentive to remain in the good books of these companies. This means that these industry specialists are susceptible to lobbying, and they can be exploited by these companies because they have the incentive to remain in the good books of their company, because they want, for example, future jobs. They might want to continue their future job within the industry, and therefore they don't want to be in the bad books of these companies. Therefore, the problem is that there exists no public accountability for these corporations, meaning they can get away with bending the law in these negotiators and somehow convincing them that the environmental harms or the health hazards that they've created are not as much, and they're able to get away with it. We don't want these corporations we don't want these corporations to be able to curb justice like this, because we think under our policy, if it goes through the due process in the court, that's when more evidence can be collected. That's when the prosecution can actually call on more witnesses, more evidence. And even if it means taking more time, we think it means preventing any type of exploitation can happen in the business. And the example can be seen as the FCC chairman in the United States, right? He was a former lobbyist for Comgas, meaning he does have vested interest in preventing excessive financial losses to oil corporations working within these countries. Therefore, we don't want these existing relationships between these regulators or these people involved in the negotiation process to have any involvement within the justice that has to be dictated, right? Secondly, how under our policy, it is only under our policy where we are creating a precedence in the industry. So what happened? Sit down, right? So under our policy, when these cases do go to court, we think as long as it takes, at the end of the day, they set precedences for future cooperation, meaning it's not just about environmental damage or oil spills or deforestation. These are financial transactions, insider trading, or fluff hedge funds, things that continue to exploit consumers because of the fact that they're always able to get away with it. Companies like Starbucks, because of the fact that they can get away with tax evasion in the UK, they continue to rip off millions of dollars of people in the US and other parts of Europe. Therefore, we think it is only under our policy where we set up precedents for proper behavior for these corporations. So what will happen? Before I move on to what happens, yes.
Sometimes prosecution teams have insufficient evidence based on mere technicality. So what kind of precedents do you set when you force every single prosecution team to fail in the eyes of the public and the court of law?
We think even if those cases happen, at the end of the day, the public sees that the government has done, or the prosecution office has done its best to take these companies to the due process of the law. We think even if these cases exist, the benefits provided under our policy outweigh them, right? So what are the precedents set in the industry precedents set by us, right? Number one, companies actually know the expectations and standards within the industry, meaning they won't be able to get away with process. They won't be able to get away with, for example, releasing certain types of hazardous gas or oil spills in riversides or oceans, meaning their externalities are continuously scrutinized. And the fact is, under their policy, since these companies don't know the judgments of these and everything happens in confidentiality, a lot of companies or small and medium enterprises don't know the things that they're liable towards, meaning under our policy we make a lot of expectations and standards clear, especially towards environmental damage or health hazards. And secondly, even if a lot of these medium or small enterprises don't know, can't figure out the standards or expectations, we think a lot of bigger corporations will hire even more legal experts and pump up their legal ammunition to be able to prevent any damage in the future, meaning increasing a lot of the irrelevant costs for their consumers and reducing the profits for shareholders at the end of the day. So why do we want the public to have full knowledge of these cases, right? We think transparency is extremely important to the public, because even though we purchase the products of these corporations, we want to know the social impact of every good that we purchase, right? Under their policy, these companies are continuously able to get away with the social byproducts of their processes. Under our policy, if citizens know and are able to contribute as witnesses or come together as through class action lawsuits, they will be able to create a bigger change and actually lobby their politicians and local governments to be able to create higher regulations and higher laws especially for environmental protection or standards in certain products. At the end of the day, we think that the time and cost saved by settling for out-of-court settlements is not worth is not worth the justice that is lost. We are very proud to propose.
you very much, Sarah. Now to continue and start the debate from the opposition bench, I'd like to invite the leader of the opposition.
Mr. Speaker, when seeking reparations from corporations, it is sometimes necessary for the state to sacrifice arbitrary notions of justice in exchange for immediate financial relief for aggrieved victims of financial crimes. In deciding this debate, ladies and gentlemen, we need to analyze and quantify the value of settlement payments and juxtapose it against the merits of getting a guilty plea or a successful conviction. This debate is not about whether or not we should punish guilty corporations or whether the state and victims of financial crimes should be compensated or not. This debate is about two things. Firstly, should we prioritize full-fledged court proceedings which may or may not be successful in garnering a successful conviction, or should we allow prosecution teams the leverage and the option to have out-of-court settlements? Secondly, which policy better ensures reparations for the victims of financial crimes while still upholding basic principles of the criminal justice system? The model that UT Mara will propose from opening opposition is fourfold. Firstly, we will set up tribunals consisting of industry experts, legal jurists, Supreme Court judges, and union representatives in order to get as diverse and as fair an opinion as possible. Secondly, these individuals will be necessary to investigate and audit these investigations, to find evidence, and also to value how much exactly these corporations pay back. Thirdly, we'll give them an option for a disclosed fee that will be disclosed to the public, but other forms of information and data will be kept confidential from the public eye. Fourthly, the payments from the compensation will be given and prioritized to the victims who have suffered these, people who lost their pensions, people who were laid off work, for example, and also the rest of the money will be given to empower enforcement agencies like the Financial Crimes Unit, like the Security Exchange Commission. These settlements will only be given with cooperation from these corporations, that they give some sort of information and data in exchange for these settlements. Before I move on to my argumentation, where I'll talk to you about the imperative for out-of-court settlements and why it's principally consistent, a few rebuttals. Firstly, the Prime Minister said that the tribunal is sometimes skewed because there are people who sit in these tribunals who have a conflict of interest. Firstly, we say that that's an argument against corrupt judges and not an argument against financial settlements. We're happy to support more background checks, and we won't allow individuals who have a conflict of interest to sit on these tribunals. But we tell you that a lot of these settlements are done by prosecution teams, and prosecution teams aren't accountable to voters or lobby groups. They have clear performance indexes to decide whether or not they have performed their job well and whether or not they have stayed integral in carrying out their duties. But even if the prosecution is part of the state mechanism, we say that states are, although yes, we do agree that states do receive donations from corporations and lobby groups, but at the end of the day, states are accountable to voters, and voters aren't going to let states to get away by being puppets of corporate America. So you look at, for example, in Texas, Governor Rick Perry was recently found guilty of, blackmailing his head of his judiciary by withholding payments. We say that there's huge, big enough backlash, and regardless of whether or not Governor Rick Perry gets money from the Mormon Church or the National Rifle Association, we think that voters at the end of the day will have the say as whether or not he stays in office. Secondly, she told you that we need convictions to improve regulations and enforcement. Not really. We say that oftentimes the information that we get from these, in exchange for these settlements, are not disclosed to the public, but they're used by enforcement agencies to go after bigger fish in the pond. That's why when Standard Chartered paid their $300 million out-of-court settlement 2 months ago, that allowed the Securities Exchange Commission to go after the banks like Bank of America, like JP Morgan, for example, and got even bigger compensation payments for them. So sometimes, yes, this information doesn't get out to the public, but you need to tell us why it's very important for the public to know that, and not necessarily the enforcement agencies. Lastly, about deterrence, we think it's rather naive for them to assert that when Bank of America paid a $70 billion settlement payment, that wasn't enough of a deterrence, that wasn't enough of a chunk of their yearly annual revenue in order to deter them from doing this again. We don't think that's mutually exclusive. So moving on to my argumentation. Firstly, why it's imperative to have out-of-court settlements? In the sport of corporate headhunting, it can be a tedious and exceptionally complex process to try and get banks and corporations to justice. But we think that there are three reasons why we need out-of-court settlements. Firstly, there can oftentimes be a lack of prima facie evidence on the part of the prosecution. So although the prosecutions have a general idea of the guilty act that these banks or corporations committed, the judicial process requires that you need enough evidence beyond reasonable doubt to prove that the acts of these corporations were indeed a guilty act. This requires more time and more money for the state to pump into these investigation processes. Oftentimes we think that in these instances, you need prosecution teams to have some sort of leverage so that they can, so even without drawing out the court process or taking a longer time to get justice, they can necessarily use this leverage to get out of court settlements. Secondly, the need for immediate relief. Oftentimes, a lot of the victims of financial crimes are people who lost their pensions, people who are literally living without homes, losing their mortgages, living without a job, and not being able to even put food on the table. Sometimes we need to sacrifice what could potentially be a larger settlement that comes, let's say, 5 years in the future for immediate relief right now, because these are people who need it most. And we think that's exactly when the state should prioritize that. We think also companies are incentivized to pay out money in settlements compared to court-ordered compensations, for example, because necessarily the companies will be incentivized to cut the court process, and also because paying out during a settlement isn't necessarily a total admission of guilt, but necessarily an implicit one, something I'll talk to you about a bit later. Before I move on, yes, Terence.
Do you agree that there is a possibility you will get a smaller amount out of this private settlement out of what you could win from?
I agree, but the marginal utility of each dollar increases because the victims need that relief right now and not 5 or 10 years down the future. So the dollar is worth more now than it is 5 years in the future. Lastly, why is it principally consistent with the roles of the criminal justice system? Firstly, we say, although it's important for the law to remain consistent, the raison d'etre of the existence of the legal judiciary is to promote, is to give back and to uphold justice and to give back to victims who have been wronged. So firstly, we say there's a utilitarian benefit to this. Oftentimes, the judicial process needs to sacrifice some idea of victims' justice in exchange for actual objective and concrete benefits. The same way how we allow plea bargaining in courts. So sometimes, a drug smuggler may get a lesser sentence compared to others, but because he has given information that has led to the state being able to enforce the crime better and reduce victims, the number of victims in the future, we say that's a utilitarian benefit that we have. Also, paying out a settlement is an implicit admission of guilt. So we don't think these companies get off scot-free. So although we agree that they need to be punished, we think necessarily that paying a settlement doesn't completely alleviate all guilt that is attached to these companies. For all these reasons, Mr. Speaker, we need to be objective in what we deem to be just or not, and for that, side with opposition.
All right, thank you very much. To continue opening governance model, I'd like to invite the Deputy Prime Minister.
And Bank of America and the company that was responsible for the BP Gulf oil spill paid those enormous amount of money, it's 70 billion on 11 billion respectively. They're not merely paying for out of the result of out-of-court settlements. Those were the numbers that were deemed by the judiciary after they've gone through the entire process of the judicial process. What does that say exactly? The thing about the judicial process is this: it actually evaluates the full extent of the damage that these companies have done, and evaluates and awards it and punishes the companies accordingly. When they were talking about those amounts, it effectively reflects the actual damage that these companies have incurred. There are two arguments that I'll talk about in my speech today. Firstly, I'll analyze what exactly the purpose of out-of-court settlement and how it doesn't apply in this debate. And secondly, I'll go to talk about what happens before and during out-of-court settlement specifically that actually is greatly advantageous towards the corporation. But before that, a few points of rebuttals. Because first and foremost, when Rafiq was talking about this environmental damage, for example, I have to say that when we're talking about this environmental damage, these environmental damage are incredibly objective in nature, in the sense that you can actually evaluate the financial cost because of the environmental damage. And second thing is, it occurs over a long period of time. So when it occurs over the long period of time, exactly just the victims need money now. But the thing is, when it comes to evaluation of a long period of time, the amount of that money that they receive at this point, i.e. now, is going to be minuscule if you're to overlook the cost that they have to bear later on in the future. Because if you're talking about reparation when it comes to environmental damages, and it comes to unemployment, for example, these are the sorts of things that these people have to suffer over long periods of time. So even if you give a small amount of money right now, that amount of money will not be of use for them later on in the future. So yes, it does occur for a large amount of times. In fact, judicial process has significant and not marginal utility. But secondly, he was talking about the prosecution teams, about how they would not be tainted, so to say, with corporate interests. We argue the opposite, because necessarily, even if you're going to talk about elections reflect governments as a whole and not on the specific basis that we're talking about right now. When we're talking about out-of-court settlement, we're talking about specific individual who deals with specific corporations. If you're talking about government as a whole, voters have to take into consideration how that government fares, for example, when it comes to foreign policy, social welfare, and so on. It doesn't necessarily reflect their behavior with regards to corporate interests. So when we're talking about corporate interests, for example, Sarah explicitly explained to you about how these people, especially because it's confidential, it's non-transparent, the prosecution team can in fact be advised by the so-called industry experts, which is the former lobbyist who currently heads the commission right now. When that happens, we don't necessarily know what's going to happen right there and then, but we can probably surmise that because they have an overwhelming interest in preserving the financial status of the corporate, so that they later on will preserve their financial incentives, we think that it's not necessarily the best of system. But I've got to say nothing to say to that.
Having an out-of-court settlement ensures that victims get immediate relief right now. Even if you get a successful conviction against the corporation, they can still use the appellate courts, use other legal loopholes to drag on the process, and it means that victims suffer even more.
You're assuming here now that the individual citizens have the kind of financial largesse to take on big corporations on their own. We depend on government simply because we on our own cannot do that. Let's talk about the purpose of the court settlement. The court settlement. It is originally meant to cater to a citizen to take their own concerns over the subjectivity of their own and the immediate concern that they have right now. Exactly what Rafiq has said. And that subjectivity is especially enhanced, especially when they're talking about those kind of stuff like what they need immediately in that instance. But the thing is, especially if you're talking about damages that these companies have incurred, they occur on such a large and enduring nature, to the extent that their subjective notions have to be overridden for the purpose of a greater public benefits. Because necessarily, when we're talking about reparations for the environmental damages, if you're solely focused on making reparations to specific individuals, we are going to have different standards, and companies are not going to, and prosecuting team will never ever surmount an effective team against the corporate interests. Hence, what we have to prioritize as a prosecution team, as a government, is to surmise the entire picture and exactly evaluate on what we can actually gain from tackling this corporation through the judicial process. Now, Rafiq here said something about the technical stuff that it will eventually make us lose the battle. We think even if in the instance that we lose the battle, it is a good thing, because necessarily we're allowing the judiciary to set standards in which other people can take up course later on in the future, if in the instance that something happened again, the similar principles can apply. But that argument basically ignores the commercial interest argument that Sarah has presented, because when we are able to lay out carefully the duties of the corporations and the liability that they may incur, what we're able to do is that preserve the same corporations from incurring any extra legal costs that then might have been necessary. But on the other hand, if that doesn't happen, we argue necessarily by putting the standards in the first place, by putting the standards, we are able to ensure that other citizens know their chances when they want to take up their cases against this corporate interests. What happens actually, moving on to the second issue, what happens before and during out-of-court settlement? Because necessarily, yes, we need more witnesses. There's an implicit agreement by Rafiq that we need more witnesses and so on. out-of-court settlement, its sole purpose is to cut short the time and the duration where the company is put under public scrutiny. When that happens, there'll be no public demand for this company to disclose. There'll be no public pressure for the corporations to extract information from those corporations. What happens here when everything is secluded behind this facade of an agreement between these two entities? What happens is that people of this corporation are inevitably going to escape from that kind of liability. Look, corruption and abuse may seem like a vague, abstract notions to you right now, but the thing that matters here, we don't know what happens behind those veils. But we need to know that we need to ensure that those things not even have the chance of happening, especially if you have to consider the extent of the damages are so massive that we need to fix this in the future, if that is the cost that we'll have to take.
Thank you very much. Now we end the opening half of the debate by inviting the Deputy Leader.
Ladies and gentlemen, in my speech, I'll talk to you about two things. Firstly, I'll talk to you about why the reality that government proposes in this debate requires that courts, as well as prosecution teams, risking losing the amount of legal capital that they need at the time, ladies and gentlemen, in order to garner as much money as possible. Because we agree to some extent it's a possibility that you might get more money under the side of government, but we think it's even more likely that you won't get anything at all. Secondly, I think it's worth noting that most of the time, disasters like the Bhopal oil spill happens in third world countries that are at a disproportionate disadvantage when it comes to lobbying or even filing cases against multinational conglomerates like BP or Exxon. We think this proposal fundamentally disadvantages prosecution teams from these countries, disenabling them from having any sort of leverage in prosecuting these companies. But before that, I'm going to engage in some rebuttal. First and foremost, we think that Audi was quite scant in its analysis in regards to response to Rafiq's speech. Why so? Firstly, we think that Rafiq spent a significant amount of time talking about how prosecution teams oftentimes get hamstrung by the kind of insufficient evidences or even the technicalities that bog down prosecution teams. And why do we say this happens more in these kinds of cases as opposed to any other criminal cases? We're talking about large-scale disasters like the Bhopal oil spill or other assorted disasters that happen in society. We're talking about, for example, evidence not being able to be garnered because they get lost out at sea, or the destruction of evidence, or for example, that oftentimes these companies block prosecution teams from collecting evidence based on things like IP, or even things like not being able to enter your area of business, ladies and gentlemen. Most of the time, these evidences are lost due to technicality or the lack of expediency in which governments approach these topics. This means that there's a large proportion of the time that prosecution teams are disadvantaged when it comes to evidences, but for the general idea, they know that these companies are responsible. Just like in 2010, when HSBC Bank will very, very successfully escape prosecution after extending and dragged on the case for 3 years after their complicity in the subprime mortgage crisis, ladies and gentlemen, by using legal lacunas. Like, for example, the UK and the US have different laws, and therefore we aren't responsible for things that happen in either country. We think these are the kind of lacunas that corporations thrive in, that countries necessarily suffer in as well, ladies and gentlemen. We think that the response from Audi was insufficient because he told us that, okay, it's fine if you lose, because at least governments are able to set a standard as to what you can pick up the ban on later on. We have several questions. Number one, what is this standard that government sets? Because the only standard that it seems to be setting on this side of the house is the precedence of failure on the state, ladies and gentlemen. Because if all governments can see, or corporations can now see, that they can defeat under certain circumstances the state, ladies and gentlemen, it is more likely than not that corporations will use that case as an exploitative avenue for the state in order to ensure that they succeed in future cases. We think setting a precedence of failure is never a good thing. They haven't told us why setting that standard will suddenly immediately form a good precedence, ladies and gentlemen. Secondly, we think this is a very important point by Rafiq, that it creates marginal utility. Because sure, we may be able to accept that you might get more money in the later on, ladies and gentlemen. But what you haven't proved is the guarantee of success of your successful conviction on this side of the house. This means what, ladies and gentlemen? That you might get, sure, 5 billion more next time, ladies and gentlemen. But the same people you're talking about, the local fisheries and farmers, as well as the individuals that have lost their homes and livelihoods, are going to suffer today. And those individuals are not going to be able to eat. Those people are going to get sick because of polluted waters. And a lot of people are going to die. Ladies and gentlemen, are you willing to sacrifice a probability of success, and a very small one at that, for the immediate concerns of individuals on the ground that are probably going to suffer a whole lot more on this side of the house? We think we win that comparative largely. But lastly, in regards to preserving corporate interests, in regards to individuals on regulatory boards having an interest to preserve the corporations after they finish their stint with the government. Number one, we've already told you that governments have an interest to keep their prosecution teams in line. In fact, prosecutors that are affiliated with the government and don't work with industry professionals are always present during these negotiations. But secondly, also the records as well as the data that's collected during these prosecutions are oftentimes released 15 to 10 years later, just like how presidential records in the Oval Office are released many years later on. The concern here is immediately, can we get some leverage over corporations to get them to make concessions? We think that happens under our side anyway, ladies and gentlemen. But lastly, we think this is very important. Under their side of the house, you're still going to use industry professionals and everyone that you say are corrupt and individuals that have corporate interests, because you need them to assess and audit your damages anyway, ladies and gentlemen. And the court will rely on the information on these people anyway. So we don't see how that harm is mutually exclusive under this side of the house. Before I go on any further, my substantive material, I'll take closing.
Now, do you agree that this case wouldn't be a court precedent in the future and would complicate future investigations for similar cases?
Ladies and gentlemen, obviously if we lived in a utopia where every court case was successful, then of course we could maybe concede that benefit. But the reality is it isn't, Terence, just like the tooth fairy. Right, so let's go on to my substantive material, ladies and gentlemen. Why do you lose legal capital as well as severely diminish third world countries' ability to fight against large-scale conglomerates? We think this is a very important substantive. Why so? Because in prosecution teams all across the world, ladies and gentlemen, even if we concede that you take it to the fullest extent of the law and on a marginal level you succeed in convicting these corporations, we think in that scenario it is more likely than not that the court will be less willing to grant full legal damages, ladies and gentlemen, because of the criminal punishments that you're going to attach to the CEOs as well as the members of the company in this instance. We see this all the time. When prosecution teams don't have enough evidence to prosecute an individual to the full extent of the law, you have the court always awards on a marginal sentence, or only not the financial damages, but only the criminal damages, ladies and gentlemen. We think you give prosecution teams less flexibility in terms of trying to maneuver around, number one, a lack of evidence that due to technicality, but secondly, ladies and gentlemen, the ability to have more legal capital with the courts in order to say that these people should be paying money. So on a comparative, which do you value more? The immediate relief of money or the legal abstract principle of just wanting to take a person to court, ladies and gentlemen? And this is even more harmful when countries like India, Madagascar, ladies and gentlemen, are countries that don't have not only the financial capacity, but legal know-how in order to fight against legal entities and the legal teams of large-scale conglomerates. For all those reasons, we think at this point in the debate, opening opposition has clearly taken this debate. Thank you very much.
Mr. Chair, private settlements to me are like the KFC double down. When I don't have it, it's so tantalizing and I want to gobble it up in secret. But when it is an option, you question its place in civilized society. Let's look where has the debate gone to. opening government decides to talk about regulatory bodies and how certain people may have a conflict of interest. A great demonstration would be me taking care of Izzat's burgers. But look at the opening opposition here. There are several things that we like to pick a bone with. Is that firstly, is that what if there's a lack of evidence? Well, clearly if there's a lack of evidence, there must be a reason for it, number one. And number two, they say that you have to prove beyond reasonable doubt. But then again, the examples that they brought were civil wrongs. When it comes to civil wrongs, it's always on a balance of probability instead. That means if it's more likely that there is something wrong there, then the courts would go into that. The second part that we have to tackle is that according to them, huge delays would somehow force people to actually suffer the brunt of what has these companies done before. But you have to be logical here. In fact, we have a real life example like how in BP Oil in the past, that within this period, they would want to actually repair their image and they have a huge PR image. That is where you force BP Oil to probably pay welfare for people within the Mexican Gulf. That's where fishermen there actually receive a lot of money from BP, even though they lost the case towards the end. So within that period, companies like BP will pay for those losses. But thirdly, here's the thing that came out within my POI that he just ignored it like the tooth fairy, just like how he ignored the reality of his life. But let's look here, is that when it comes to court precedents, you have to see it as a form of investment. You have to delay it, you have to spend more money in it, so that in the future, when you have similar cases, it's easier for the state to actually win the case at the end of the day. Private settlements does not allow those forms of court precedents, and somehow people would actually have to start the investigation all over again. And by that time, corporations would already learn the loopholes within the situation and force it even harder for attorney generals to fight for their cases. How is closing half going to be different here? Closing half is going to be very different by talking about the nature of punishments and how it should work within a civilized society. And might somehow come here and talk about 10 different court cases that I would learn for my future exams. But before I move on to my argumentation, any of you?
Don't you think that when the case drags on for 5-10 years, that individuals on the ground will be apathetic and lose political steam, therefore making governments and prosecution teams not want to pursue these cases as fervently as they do right now?
That's even worse. Why so? Because now you are preying upon the weak, people who are desperate. That is where the courts have to actually understand that these people have a bigger benefit when you think that you can get the evidence. Just like we said, maybe these people would somehow lock up their compounds and say, you cannot enter to get the evidence. Within those 5 years, the courts can try to get an injunction to do so. This is more like an investment. Well, we are talking about companies making money anyway. All right, first argumentation, how private settlements is incompatible with deterrence against corporations. Firstly, let's characterize the corporations' private settlements, something that I wish OG did it a little on so that I wouldn't spend too much time. Firstly, corporations have more money than the average person, giant PR team to fix their image, and huge incentive to stay out of the limelight, i.e. get into something secret in the bad. Okay, but B, private settlements is that most of the agreements are secret, and here's something that OG didn't talk about, is that these corporations would always have the plausible deniability when these settlements are generally secret. That means when the media starts to scrutinize, the first thing they can say, this case has already been settled with the people involved, why should we actually scrutinize it even more? But let's move on to the second part of this argumentation. What is the point of punishment then? Is that in punishment, generally you have deterrence, retribution, but for an institution like corporations, we have nobody to put behind the bars. So how do we deter the wrong acts done by a body that we couldn't jail? So now, considering those two characterizations, the way we do it, the way we actually do it is somehow to actually put a certain form of financial burden. And how is it now incompatible, judging from these characterizations? Two parts here is that firstly, within a private settlement, you don't have the typical judge scenario where he oversees things as a neutral arbiter. This is where corporations somehow could directly talk towards the victim, who may at the end of the day drop the cases at their whims and fancies and not directly on the prosecutor's will. So the lack of a judge means that corporations act as their own judge. So the idea of the punishment is normally to fulfill the full run and not to suffer the full extent of the financial punishment. At the end of the day, this is no different from just another form of financial calculus that a company would do. This is merely an extension of accountings instead. So what you're saying here is that may as well we pay people, we let them choose their punishments. Now, at the end of the day, private settlements is an euphemism for paying people to shut up. But before I move on to the second part, Closing that.
You claim that these courts will eventually win the cases later on. This means that there is some semblance of the lack of corruption. Why is it that you assume that all these extension of the court, i.e. the prosecutors, will consistently be corrupted? What are we, third world nation, Africa?
I'm not saying that it will be constantly corrupted. I'm saying that we should somehow invest more into actually investigating these kind of things in the future. We're saying that we should ban it totally so that at least when there is scrutiny, when there is a form of corruption, if you want to actually talk about constantly, at least the media can work as the fourth estate into pushing this and see if there is something wrong within it, something that Habib directly ignored in his POI. But here's the second part of my extension, is that deterrence is also to judge a character so that people can choose whether to associate with that company or not. Now, let's look at it like this. Private settlements is technically ammo for corporations to call possible deniability. Now that everything is kept a secret, no one knows the details, probably like we said, 20 years down the road. But the difference here is that this kind of things happen on the ground constantly. They still operate within the business. That means their financial instruments are still up for people to apply for in between. And people want to know whether should they associate themselves with such financial instruments and somehow pay for this kind of things. People want to know how did they cheat the financial instruments? To what extent is the failure of BP? And how has the logging companies destroyed the ecosystem of Guatemala? The problem here is that any inquiries that people face is that there would be a notice saying that this has been settled. At least within a court case, people can judge and say, look, there is something questionable about a company. Let me disassociate myself from that company first. And then if it is done and somehow it's proved the company is right, then I can choose to do so out of the judgment of character. The rest of the media are also less incentivized to go with investigative journalism because they think it's already done. At the end of the day, it's simple. We need to get this into court, make it into paper, and make sure it turns into precedents so that in future investigations, it will be easier. Go on one side, let's ban this abhorrent act.
All right, thank you very much. Now I can invite the extension speaker of side opposition.
The justice system is not without its faults. It's very easy for side government to just identify one arm of the justice system and tell us all of these harms associated with it. But harms per se don't nullify the structural reasons as to why certain sections of the justice system must exist. CO will provide you all of these reasons. We think the circumstances surrounding each case is different and the justice system requires a structural flexibility to deal with those circumstances via organs such as the out-of-court settlement. We're going to provide you 4 layers of extension on why these out-of-court settlements must exist to aid the role of the justice system. Firstly, swift justice. Secondly, equitable punishment. Thirdly, judicial pragmatism. And fourthly, loss of autonomy for actors involved. Why do we think this is more important to the debate than what came out in the opening half? We think ultimately this is a debate about the structure of the justice system and how those structures aid justice. It's not about mere harms and benefit that you've heard already, because they don't give clarity why uniquely these structures must exist because of principal justifications behind it, and not just because they can exist because there are some harms or some benefits to it. Before that, let's look at 2 main rebuttals. Firstly, let's rebut the extension coming from CG. They told you this policy is incompatible with deterrence of corporations on 3 levels. We'll give you 3 responses. Firstly, they said that the media is unable to scrutinize the case because it's settled. That's a rehash from opening. But here's our response. Just because the settlement is done, it doesn't mean blatantly wrong corporate actions will suddenly escape the scrutiny of the public eye. The fact that the case is being investigated right now, that means there was a class action suit in which there was a movement on the ground that brought that case to the eyes of the prosecution. We think discourse can still exist because discourse is what brought prosecution to come to the eyes of the for those corporations in the first place. We don't think they will cease just because it's settled, because details will still flow about, media will still flow about, and if not, discourse can still happen but if those wrongdoings are so implicit to policy making, we think we can make an exception to confidentiality clauses like we do on the status quo, because the environmental laws are so important and we need to have discourse on these blatantly wrong corporate actions. We think society is able to make those judgment calls and not just stop talking about things because they're sheep and just because something is closed and they will not talk about it. The second response, take a seat. They said that corporations will act as their own judge. We disagree. An out-of-court settlement is a mutually beneficial agreement that all parties believe must reconcile their differences. So in this case, even if the corporations are victimizing the prosecutors, if the prosecutors disagree, they can equally perform a deadlock that will create a stop to those agreements that the corporations may want it to prevent. If you're talking about financial bullying, those are not harms that are mutually exclusive to out-of-court settlements. It was easily happen within a long, drawn-out trial process as well, where you force the prosecution to present paperwork and drag it out for as long as possible. Those are harms that we regret, but most importantly, it's not part of this debate because we can't prevent it either way. Take a seat. Third response, what about corporations who deserve vindication? They only want to talk about media scrutiny on corporations that did wrong and therefore they have to deal with it. We think you will create a long-lasting affair with the media for a lot of corporations that deserve vindication. Their brand will be unfairly defined by the one wrongdoing that happened in the court. There was a huge media circus when these brands maybe have had reformation of those practices, maybe have had contribution and funding towards better policy making and better industry practices. Some brands that deserve to be vindicated from those labelings that you unfairly impose onto them because everything has to be a public affair. We think you're not dealing with a variety of actors that are included in the status quo. Secondly, a brief rebuttal against opening everything else would be dealt with in Habib. They said that principles of justice is undermined when it comes to judicial precedents. But the thing is, things like arbitration are also out of court settlements and they are also judicial precedents, guys. You can quote arbitration as precedents. In fact, you can quote any scientific authority as precedents, just possibly not as much weightage and authority. But if it's smart, the judges are able to make a judgment call on what's valuable and what's not. Guys, let's look at 4 principles on why there is a judicial significance to out-of-court settlements. But before that, closing.
Now, if you agree that in your characterization, both sides have financial bullying, why is it you have to go to one without a form of precedence then?
Because I have 4 judicial reasons as to why out-of-court settlement must structurally exist and addresses a lot of circumstances that need to be addressed. Number 1, swift justice. There is a central legal maxim that defines the justice system, which is justice delayed is justice denied. Opening tells you why there's going to be time delays, but it never told you why time was so crucial to justice. That's the first level. Why is time an important tenet of justice? The trauma experienced by victims are accentuated when you're unable to deliver closure on a timely basis, because now they will suffer a prolonged sense of oppression without any sense of the matter being addressed. Oftentimes, they feel actively victimized by the trial system because they are interrogated by judges, they are forced to give evidences when they are the innocent victims within this party. But B, it tampers with the legal reality that all of these people face, because evidences can be destroyed. It can become a black hole of funds. Parties will become so consumed with their version of justice that testimonies become more and more unrepresentative of the actual reality. Therefore, the level of justice delivered is significantly undermined when you delay things. Second level to this first extension, why will full trials take exponentially longer than out-of-court settlements? Because full trials have to overcome legal realities, such as the schedule of the judges and schedule of the parties, such as you have to observe a mandatory waiting period between delivering of certain documents. And according to corporations, this can happen 50 times over the entire duration of the case. The minimum time served is exponentially longer than a settlement. And additionally, you have all those financial bullying that happens where you have to serve a lot of documents. Swift justice is actively being deprived on your side. Second level, equitable punishment. You have to question, what if these corporations want to have swift justice, and what if they want to plead guilty and proceed to paying reparations? Because however, they are not agreeable to the extent of guilt that is being attributed by the prosecution. There will be a legal loophole on the status quo in the absence of out-of-court settlements. How? Because now when you plead guilty, you are now stripped of the ability to agree on the extent of your guilt. You are forced to agree on the full facts of the case without the ability to make amendments, because there's no such thing as plea bargaining when you cannot negotiate your case via out-of-case settlements. Now your punishment becomes inequitable, because just because someone pleads guilty, it doesn't mean they plead to the extent of guilt that the prosecution has attributed to towards them. In fact, these are the exact actors who deserve vindication because they recognize their guilt. They want to help the process, but they cannot do anything but plead guilty in order to have swift justice. You deny them equitable punishment. Thirdly, pragmatism. The justice system defines justice based on pragmatism because time and resources spent on your case is an opportunity cost to other case that deserves those limited resources. That's why we give an automatic one-third reduction of any punishment when you plead guilty because you're saving the time and resources of the court. That is just judicial pragmatism. Fourthly, losing autonomy, Mr. Speaker. Court proceedings removes all autonomies from all actors involved. You have no say in the future of the case. That's why we only subject individual actors to this when they are irreconcilable competing differences and we cannot do everything to negotiate. In this case, there'll be a lot of corporations and prosecutions who are willing to negotiate and have an autonomy and say over their own legal future. These individuals deserve those kinds of judicial measures to address their circumstances. For all of these reasons, an out-of-court settlement must exist as an avenue to address those circumstances.
All right. Now we end the government event with the government speech.
The justice system is a system that independently executes and deters. This should not fall on wrongdoers, but rather it should be executed by the justice system itself. Ladies and gentlemen, I'm going to be doing three things in my speech. Firstly, I'm going to be addressing closing opposition's extension. Secondly, I'm going to be addressing the extension that came from our side. And then I'm going to talk a bit about opening opposition. Let's immediately go into the extensions that came from closing opposition. The first thing that she talked about was on swift justice, on how time is extremely important to not just the victims, but also to coverage in of itself. Here's the problem. The reason a lot of the times these courts have to delay, or the reasons why, say, evidence, for example, couldn't be found, therefore it has to be delayed, is because of the fact that the balance of probability doesn't exist there. The problem here, Madam Chair, Mr. Speaker, is that more often than not, the reason time is delayed is because they are not able to determine immediately whether a party is immediately guilty or not. And the problem here is that is exactly the nature of the legal system in by itself. The reason for this, Mr. Speaker, is because the legal system immediately determines whether a person is guilty or not based on whether there is adequate evidence or not. If there is any lack of this evidence, which will lead to a time delay, mind you, fine, but it would still then be able to prove whether a person is actually guilty or not. We think this is far more important because, one, we are not going to be victimizing someone who is not guilty, who is not able to be proven that he is guilty. But second of all, then we will be able to be assured that justice is indeed proven, that justice is indeed served when that particular corporation has already been determined as liable. Second of all, she wanted to talk about full trials and why it's simply tedious for us to constantly rely on full trials. The problem here is that the problem that she had are all administrative in nature because, Mr. Speaker, first of all, a lot of this administration is extremely important because we are able to fully organize, we are able to fully understand and also allow justice to be dealt efficiently. But more importantly, this is not good enough of a reason or not good enough of a justification for us to completely undermine the trials to begin with. And the reason for this, Mr. Speaker, is because there are a lot of different benefits I'll furthermore talk about in trials when it comes to determining whether a particular party is guilty or not. Equitable cooperation. The problem she had with this particular idea is that now companies are able to plead guilty, and therefore that we won't be able to receive the same compensation that is indeed important or indeed equitable for the victims. The problem here is that no, thank you. It's still the same. On the first response is still the same on their side because by their side they are still able to determine as to whether the compensation they are giving is appropriate or not. They still are able to choose the compensation, so it's not that similar on that side as well. But the problem here is, first of all, under this side, regardless of whether a company company is able to plead guilty or not, when they are in trial, when they plead guilty, the judicial system then determines that individual as justly when the company then compensate after plead guilty, it is still justified. No, thank you, because of the fact that when the company compensates after plead guilty, when a company compensates after a plea guilty, the judicial system then determines that person as just and then reserves the compensation that he actually gives. The benefit here is that the corporation then still gives a compensation that is just as determined by the judicial system, even after a plea guilty. No, thank you. Then they wanted to talk about autonomy, on how now there is no full autonomy when it comes to deciding cases or when a corporation is tried. The problem here is that, firstly, that's how it's supposed to happen, because in all these trials, there is not supposed to be any autonomy, but rather the reasonable person's judgment. Because in the case of a jury system, for example, then it all comes down to the reasonable apprehension of that particular jury himself. So we don't think that any autonomy is actually even needed, because that is exactly how the legal system operates. There shouldn't be any hands, there shouldn't be any determinant factor when it comes to determine the justice system. No, thank you. Let's look at closing government's extension, because the first thing that we need to point it out is that there is no response in regards to how we are now creating the ability for companies, for individuals to want to choose as to whether they want to associate with a company or not. Because by the end of the day, it is extremely important, Mr. Speaker, that a customer has the right to be informed as to whether he wants to associate with a company or not. No, thank you. We think that this side will disallow that, because now no one will know as to whether the extent of the crimes or the wrongdoings of a particular company, and no one then, no, thank you, then no one then will be able to understand as to, no, thank you, as to whether any company, as to whether an individual then associates with the right company or not. But more importantly, let's respond to a few things that came from that side in regards to our extension. The first thing is on how no, thank you, is that now deterrence won't exactly be a problem, because there is a mutual benefit. The problem here is that under their side, it's even worse, because regardless of whether it's a mutual benefit and the victims will still be able to be compensated, it's the fact that by the end of the day, these compensations are still decided by these corporations themselves. When the corporations decide as to how much they want to compensate, it's not a deterrent factor, because when it comes to deciding in the future whether they want to commit a wrongdoing or not, they understand that they can make a choice, that they can decide as to what their fates are. Because under our side, however, this doesn't become an option, simply because these corporations then would not know as to how exactly would they end up and how exactly would they be tried. Myth.
While it is true that civilians will not know the data and the specifics, but laymen don't access that information anyway. So why is media reporting and the fact that Exxon paid a settlement insufficient spotlight for people to know and deter away from buying these products?
Firstly, that already exists in our side. There is reporting on trials every time. People will then be able to understand the extent of that crime. But second of all, most of these, the characterization under their side is that, one, it happens behind closed doors. No one may not be able to necessarily understand, or no one be able to necessarily know as to whether that particular wrong has been committed by these companies anyway. But more importantly, as Terence rightfully pointed out, a lot of these companies then talk to the victims. A lot of these companies reach out to the victims as to whether they can, one, reach a compensation, or two, as to whether they exert their political leverage, or whether they exert their power as a big company to these victims so that they would shut up. So the problem now, ladies and gentlemen, is the fact that in opening opposition, they talked about mostly lack of evidence and why we have to address this. The problem is that, firstly, when it comes to technicality, in not having lack of evidence, this rarely happens. But more importantly, it's based on a balance of probability, whereby a lot of these circumstances include judges to understand and look at the evidence as it happens. So there is no such thing as lack of evidence when we decide whether a company is right or not. We're very proud to propose.
All right, thank you very much. To end this debate, I'd like to invite you.
What you have from Thai government is two teams, they are drowning their own characterization. The same way the fishes drowned in the oil in the Gulf, the Gulf of Mexico.
So proud.
I have two issues I want to talk about, right? Number one, it was good. It was on. Right? What is best for justice and what's best for the victims? I'll deal with what's best for the victims later on in my speech because they think that this is just the argument, right? So let's go on one very simple idea, right? Because apparently closing government's extension has been reduced dramatically to just, but people don't know whether they should associate with these companies or not. You know, people need to have the choice and right to information so they can decide whether you want to associate or not. Well, clearly you guys don't read the newspapers the same way these people that you're describing don't read the newspapers also. Someone paid off another party, or a big conglomerate has made given some financial remuneration to a bunch of people. Now, the only people that you're probably targeting here are the people who cannot read and the people who don't have access to any newspapers whatsoever. If you want to know about the future, read Foreign Affairs. They tell you stuff that's going to happen even before it happens, right? My point is, when it comes to the reality of how people associate themselves with these big corporations, you don't have to come up here and make it a fully blown out, dragged out trial for 10 years that has no guarantee of success to let people know, I made the right choice in investing in their shares. That's not an extension. Good luck trying to get a point in this debate. Let's go on to the first issue. What's best for justice? You see, what you did not see from side closing government was a response or any form or semblance of, you know, an attack on whatever Mai just talked about earlier there, right? Let's break it down for them. When she talked about equitable punishment, you need to understand that these corporations, not all of them, well, they're not villains. They make mistakes. The biggest assumption they made on side government is the assumption that whenever a conglomerate or any party that represents a conglomerate sits down at the arbitration table with a prosecutor, they will always be at advantage. Opening government seems to think this debate happens in Nigeria. Closing government seems to think that at the end of the day, some judge is going to, the judge in the arbitration proceeding is going to influence the prosecutor by saying, no, shut up, don't say anything, right? So let's look at the reality. The admittance of guilt is something that opening opposition talked about, but the reality is this. They made the prosecution look extremely weak. But that's not the reality. When you have a group of prosecutors saying that you need to come in and talk to us because we have crap on you, then we're gonna make sure that we're gonna call if you don't come here. That is leverage. That is two groups of two parties coming sitting at the same table and then deciding that they have to discuss this because the corporation knows that if they don't come, this will go to court. So there is an incentive for them to come. You cannot come and say that there is a power play and the only power play and the Power Rangers there is the conglomerate, and these other individuals who are prosecutors got their degrees from BAC, right? All right, done with. Okay, so how is this best for justice? Let's look at why swift justice is good. Mr. Speaker, when it comes to the understanding of how you need to define justice for yourself, this goes on the second issue, yeah, like what's best for victims, or what's best for victims. When it comes to understanding swift justice, it's not just about the money that opening opposition talked about, where you get money and you are able to live your lives from now till 10 years down the road. It's also about the reality of how corporate badgering does happen. You have these victims being targeted by these corporations, and if you really think these corporations are villains, are bad people, then you also need to concede that they may be targeted, they may be looked at, they will be put on the stand throughout the entire period and tell you don't know any better, you don't know whether you even had a boat in the sea at that point in time. Why should I pay you anything? They diminish the credibility of these people. Some of these individuals are fishermen and are uneducated, they are illiterate, and all they know is that I'm being attacked and I know that I no longer have a sense of belonging to that sea or whatever the business I was doing at that particular part of the world. That is humiliating for them. It dehumanizes them. And the biggest problem side government has here is that the constant assumption that justice has to be on terms as if we win the case and we get 95 billion, this is justice. Who the hell are you to decide what is justice for these people? Let them decide for themselves, because they have prosecutors that are defending them and fighting for their rights because harm has been done. If these groups of people think that this is just for me, why must you redefine what justice is for them? This is extremely important, because if you want to say swift justice is important, you need to take into consideration it's not just about the money, but also about the type of justice that you get. You need to avoid these people being humiliated, avoid these people being put in positions where they're going to be targeted by corporate badgering. You need to also understand the realities that judges have a life and a family, they have schedules, they have paperwork.
all these problems and the pragmatic side closing opposition has showed you is that all these things are inhibitors to any benefits that they claim to be accrued, to be ever accrued. This is why this form of justice is the best form of justice. Opening.
No, why would such notion as justice relating to environment and the welfare of the people be subjected to the lack of skills of time management on the part of prosecutor?
Oh my God, that is the reality. It's like you have 9 arguments, but you have 7 minutes. That is the reality of how things work. You don't have enough time. You may think you have good arguments, but you don't necessarily can deliver all of them. The reality then applies then into a court system. There's 24 hours in a day. The guy can't sit there for 24 hours. If you expect him to sit there for 24 hours, obviously the decisions are going to be poor. And obviously it's not going to be justice there because people are going to be tired and no one wants to fight for their case. You know how stupid that question is? I'll take another one.
Okay, since punishment is also about admission of guilt, then how can it be equitable if companies can insert compensation into their accountings, considering they can choose to drag or pay at discount?
It's like you don't read at all. Okay, look, let's look at the reality, all right? If you have corporations, guys, listen, right? Okay. If you have corporations that's already saying that I'm going to pay for the settlement, I already explained to you about the principle of leverage there. They do admit that I've done some wrong and this is going to happen. No, it's not yours, it's my explanation, right? So what happens is that this leverage is important. If you agree that they have done wrong and we say that they are going to pay a sum, that admission of guilt already comes at the expense of them being scrutinized in public because the public knows that they've done something wrong. If there's any harm to it is a harm that they take upon themselves because they can manage that harm. They know their branding is going to go down, but they can fix it by actually negotiating with these prosecutors. In the long run, their brand will eventually come back up. It's a calculated risk that these corporations make. So you need to understand one very simple fact. When it comes to equitable justice and what is the best definition of justice, we think these prosecutors, when they decide to represent a group of people and they think this is good enough for them, at the time, enough money, I'll give some to Ola, right? For them at that point in time, that is the best form of justice. If you think there is a team that is just, it is this.
All right, applause, shake hands, get outside, I'm calling my team. It's not silent now. No, there's one more round.